record.
We're back to deliberating. Here we are for the Baltimore County Board of Appeals for public deliberation for a remand from the remand. I'll go through the history in a minute of 19-481-A. That's 2100 Northland Road. This was a petition for variance pursuant to section 432A.1.A3 of the BCCR to permit an assisted living facility within 1,000 feet of another property of another assisted living facility. So there was a administrative law judge order back in 12/10/2019 that denied this request. And then there was a full de novo hearing before the Board of Appeals dealing with the same. The Board of Appeals decision was that we did not find grounds for a variance, so the request, in fact, was then denied. That was timely appealed to the Circuit Court for Baltimore County. After review by the Circuit Court, we received a letter of remand from the Circuit Court concerning whether or not the property at issue fell within the statutory prohibition of a matter of feet from another facility, and they gave us the address of a specific facility that they were concerned about. So first of all, procedurally, I've said this before, I think I said this in the previous deliberation, both before the administrative law judge and this board, if you are requesting variance relief, it is never necessary and illogical to require it for anyone to prove that a variance is required, due to the fact is if the petitioner is asking for variance relief, first step one is that they say they need a variance. Consequently, we never take testimony on, well, do you really need a variance? That determination is made by the Department of Zoning when they fill out their application before an issue comes before any of the fact finders that deal with that. So as a matter of due course, neither the ALJ nor this board ever made a determination whether a variance was required. And for that point, never ever was there an issue raised either before the ALJ or us that a variance was not required. So when we received this remand, we were somewhat befuddled, but we decided in the interest of judicial economy to address it, as it usually would not be the course that when we reopen any type of evidence, the case that's already happened, but rather than going back to square one, we did remand this to the Department of Zoning, and Mr. Perlow, at the head of the zoning there, the zoning supervisor, made some interesting determinations for us. They found, first of all, that the address that was cited by the Circuit Court does not exist, but they did make a determination that there was another property located near there that perhaps was being referred to. That property was determined at 2110 to be a group home or alternative living unit, which the state exempts from any type of zoning ordinances that would be held by the county. So just to get that out of the way, that the address that we were given, for one, does not exist. Two, the other address that would be on the street that perhaps was the interest of the parties, that one does not have to have the county okay because it's covered by the state because it's a different type of facility. However, zoning provided maps for us and did the calculations and let us know that their original requirement for zoning relief was based on a facility at 6307 Carolyn Avenue. That, as provided by the maps that were provided, is within 1,000 feet, and that's what generated the zoning issue to begin with. So in short, what we have learned by the kind work of the zoning supervisor is that, in fact, this facility is within 1,000 feet of the Carolyn Avenue address, thus requiring a variance. And since we have already had the testimony and the review of the Cromwell analysis based on this facility, nothing has changed in that factual domain. So consequently, to me, This has basically verified our original assumption that variance relief is required. A variance hearing was held twice, and before us, the one that we're dealing with, a determination was made that it did not meet the Cromwell standards. Based on that, at this point in the deliberation, as we were ordered by the circuit court to take action in keeping with their decision, I believe we have taken action in keeping with that decision, and we have determined that variance relief in this case is still not warranted by the facts due to the fact it is within 1,000 feet of the Carolyn Avenue address. If there were to be an argument by anyone that that was a computation made in error or that the Carolyn Avenue one does not exist, that is a request for special hearing or a determination that's brought up with zoning that they can do it another time in another case. But as to this case, I'm satisfied that the facts that we relied on originally are still the facts that exist today. And it is my thought that basically the zoning relief is still denied. And that's what I'll say, and I'll turn it over to my colleagues.
Well, I agree. The only facts that matter, once it's established that that the applicant needs a variance, which he clearly does based on the information from zoning, the only factual question then is whether the property is unique and whether there's unwarranted hardship. And those factual questions were presented to us in full and decided by us in full, and we decided there was no hardship. We decided there was nothing unique about the property, or at the very least, we decided there was nothing unique about the property. And both of those requirements are necessary. They're conjunctive requirements. So I think your summary of the situation is exactly correct. There's nothing for us to decide that hasn't already been decided and isn't already final. The only, we need to issue an opinion that says that, and all I would suggest is that the information from Mr. Perlow either be made part of that order or certainly at least put in the record formally so that if there's further review, whoever it is that's reviewing this can see the information from Perlow, and the parties also then would be able to see the information from Perlow. It's not private information.
I believe Ms. Cannington, to address that issue, sent out Mr. Perlow's correspondence to all parties before this hearing.
Well,
so that they would be in the know.
Okay, all right.
So, but I believe it for housekeeping as things get separated, I believe you're probably right. It should be made an appendage to any order that we do. So we'll have one-stop shop for anybody who were to look at it again. But I think Ms. Cannington foresaw with her great insight of that would be appropriate and took care of that okay already.
Right. Well, as usual, she's one step ahead of everyone. So.
And I'm in complete agreement with both of you. In short, I mean, I agree.
Yeah.
All right. Well, that's where we are. So basically what we're doing, we are taking action in keeping with the circuit court's remand through extraordinary procedures. I guess we could have said from Jump Street, we're not taking any new evidence and made everyone start from the beginning. But I think this, in the era of judicial economy, was probably the best path to go. Just to make it clear, for some reason, if the Carolyn Avenue address facility were to disappear at some point in time, that does not preclude anyone from going back and asking for further zoning relief because there would be a change in circumstances. Our ruling is based on the facts on the ground as they have been presented to us from the zoning supervisor. So that being said, just so we don't have to reconvene, I will volunteer to be the pen. So I'll do this one since I wrote the other letter. I can put it together. If there's no further housekeeping, I guess we can adjourn, and I'll see you folks at 10.
Good. Thank you.
Thank you.
Thank you very much. Yep.